This is the podcast of the NOVA Center on Business, Human Rights and the Environment. Welcome.
Welcome to a new episode of the NOVA Center on Business, Human Rights and the Environment. My name is Cláudia Baptista, and I will be the research associate conducting this episode in conversation with PhD student and lawyer Paul Mougeolle. In this episode, we look to discuss and better comprehend the framework of the French corporate duty of vigilance law. The French duty of vigilance law, which was passed in 2017, requires large French companies to take responsibility for their impact on human rights and the environment throughout their supply chains. The law requires companies to identify and prevent any adverse impacts that their operations may have on people and the planet. In this episode, we have the pleasure of welcoming Paul, who is currently conducting a comparative legal research analysis of how the concept of due diligence can contribute towards the efforts to combat climate change. Paul Mougeolle is a project coordinator, legal advisor, and spokesperson for the Notre Affaire at Tous, and has previously worked as a consultant for an additional NGO, the Global Legal Action Network. He joins us in discussing the implications this law introduces for French companies, particularly in the wake of the growing climate crisis. We'll explore the possible opportunities and challenges faced by companies as they attempt to comply with the law, as well as the benefits and drawbacks of the law's implementation. Paul, thank you very much for being with us. The first question I would like to touch upon is how and why do you believe it is important to have the duty of vigilance law applied to all companies instead of merely applying to large companies in France?
Hi, many thanks for this interview and the invitation. I think it's quite an obvious opinion that all companies need to tackle human rights issues and environmental issues in general, including climate change. So it would therefore make sense to devise due diligence, human rights and environmental due diligence regulations for all companies with, of course, some things that you need to consider by devising these laws, that they have to remain proportional. So as for taxes, contribution to when you pay your taxes, everything needs to remain proportional. So if you, for instance, introduce a reporting obligations as in France with the vigilance plans. So in France, you need to show every year how you comply with the basic requirements of preventing serious human rights and environmental risks. You have to do it by publishing a vigilance plan. And I believe that the expectations should not be the same if it is a very, very large multinational company as if it would be a small business.
The second question that we could touch upon is how can the French duty of vigilance law be a model for other countries seeking to hold corporations accountable for their environmental impact?
So I think the French law is interesting in the sense that it's the first law worldwide that tried to translate the human rights due diligence concept, which was devised by John Ruggie when he established the UN guiding principles on business and human rights. So it's a first attempt to translate this concept into domestic binding law. And the very basic principles, simple. All the companies need to identify and prevent serious human rights and environmental risks. So basically, as long as the risks are foreseeable, the companies must prevent those. Otherwise, it can and should be held to account. So the law is imposing, if you will, a proactive conduct on the companies in this regard. This general clause is for me very important. If you will, I will give you a concrete example to illustrate this. In France, our work at Notre Affaire Tous, it's an NGO who is doing climate litigation. We basically started a case against Total Energies and relied on this law to try to push the company to make a better contribution to climate mitigation. So to basically reduce more intensively its greenhouse gases. The fact that the law is framed in such a general way enabled us to do that, because climate change, of course, is causing serious human rights and environmental issues. That's why the company also accepted to integrate climate change into the law, even before sending to the company a formal notice or starting litigation. And now in 2023, we are carrying out each year a corporate climate vigilance benchmark, it's called, to know how the companies are dealing with climate change under this law. And we're assessing 27 companies each year. And at the very beginning, almost no company tackled climate change in their vigilance plans. And now every company is doing it almost. And the general clause, the other benefit of it is also to enable a dynamic interpretation. So that being said, I also believe that the German model, which is very more precise, which sets out a list of human rights that needs to be prevented, even a list of a conduct that needs to be implemented by companies. That can be also interesting and useful, including for climate purposes, because it is necessary to gain time. Doing litigation takes a lot of time, especially in France, where the courts are overwhelmed by many different cases. So if you can avoid that time and already regulate very precisely, it's probably a good thing. The challenges with regulating human rights and environmental issues from a domestic perspective, especially multinational corporations. So, and especially also in climate change, you always would have the problem if the regulations are only domestic, that the possibility will remain that companies relocate in other countries. And you have many different relocations issues arising. And we also call it the substitution argument. So basically, if in the climate change debate, if one company is not doing it, another will do it. So if we achieve to impose greenhouse gas reduction obligations on companies like Total, they are arguing that, okay, if they are transitioning to renewable energy, but another business could take over their business, if you will, and could place fossil fuels on the market as long as it is not forbidden or regulated on a global level. So I think it's a very difficult issue to grapple with, and it needs like holistic regulations, if possible, on a global level. But I still believe that domestic or regional attempts like the European Due Diligence Directive are still very useful. Extraterritorial regulations like these that can contribute to solving this problem, especially if they come along with other kind of regulations. So this is another topic, but in climate change, you need a lot of different instruments to tackle the problem in an effective manner, let's say. And given this problem, it also should not be an excuse, let's say, for companies to not doing their part and to not carry out the measures that are proportional to the problem.
Thank you. So you've just mentioned the Total Energies case. Do you believe that it has helped in clarifying the environmental protection obligations that are put in French companies nowadays?
No, I don't think so. So that's my very brief answer. I will try to explain you why. So it's not my view as an activist, I would say. There's a decision that was issued in the Total Uganda-Tanzania case. It's a case that we didn't launch ourselves. It was taken by Friends of the Earth France against Total Energies for the activities in Africa. Decision which was issued in summary proceedings tried to give some answers on how it interpreted the law in a procedural way. So how plaintiffs must deal with the law in a procedural manner. So I'll try to give you some information in order so you understand what this decision did and why it is not so important, I would say, to interpret the law in substantive terms. So basically the judge, it stated that plaintiffs, NGOs need to deliver before they do litigation, a firm and precise formal notice of liability. This notice of liability, it's stated explicitly in the law that it is a requirement before filing a case. This is important for the judge so that the company can understand what are the critiques, what are the criticisms, so the shortcomings that are alleged, and what are the specific requests to redress the situation. And in this case, the judge considered that the applicants, that they had two different case between the oral pleadings and the written documents that were filed before these oral pleadings, in the sense that there were, for instance, 200 additional annexes that were filed. So it is a too big difference for the judge. We think it is problematic that the judge issued such a statement because we believe it is normal to update the allegations and the requests from the moment on that the situation is evolving. And the case was filed in 2020, and it was only dealt on the merits 3 years after, so very recently. So I think we believe it is normal. Otherwise, the judge also stated that the law remains very vague and general, and that the government didn't issue any decree to specify the content of the company's obligations. The judge also stated that the objectives of the law are monumental in the sense that they are very difficult to achieve, and that the vigilance plans that would be better if NGOs, affected stakeholders, and the companies devise the vigilance plans together. We also have to know that this judge is part of a network for mediation, so he attaches a lot of importance to mediation, to trying to find a settlement outside of court, and especially before taking any litigation. Basically, we have the impression that for the judge, this law is too difficult to grasp with. He almost deflects the responsibility to the NGOs. He finds that the government didn't do well its job, didn't give the jurisdictions and the courts enough information, enough education to deal with the law. So basically he's saying, please try to find a way to solve the issue before taking the litigation, and then we can maybe see what courts can do. But I think it's a very restrictive approach, and this is contested. It's challengeable, if you will.
Thank you very much. Finally, I would like to know what you believe are the challenges and opportunities for companies in adapting to the requirements of the French duty of vigilance law, particularly in the context of increasing climate risks and changing regulatory environments.
I think I will restrict my answer to this question to the climate area. For climate change, companies, they know very well the issue of global warming for decades now. It is a public issue. Scientists identified that there is a need to reduce greenhouse gas emissions. So companies also know very well what are the causes of these greenhouse gas emissions, namely fossil fuels, land use change, so deforestation. And this public knowledge, we believe, should bring all companies to do their part. So especially high-emitting companies, introducing fossil fuels into the market, contributing to deforestation, that they should do something to stop it, and especially these companies which have system-wide and global influence. Instead, numerous scientists, including the IPCC, so the International Panel on Climate Change, identified and documented that fossil fuel companies undermined climate science and that they lobbied against climate regulations historically. Legal experts, including in the USA, believe that companies can be held to account for that. And some attempts, climate litigation is ongoing in this regard. So municipalities are requesting loss and damages from oil and gas companies in the USA to try to find a solution against the problem of sea level rise. And if states and companies would have acted in a reasonable fashion before, there would be no need to drastically reduce greenhouse gases nowadays. That the fact is also well documented. But given this situation, companies can now expect more stringent regulations, so they can anticipate it. And they can also benefit to some extent from public money and other incentives to do the climate transition. So I'm not sure French companies which are facing this duty of vigilance obligations face higher risks than any other companies, because tort law also already enables, if you will, to do the same claims as we are doing in France against Total and others under the duty of vigilance law. And it already worked, especially in the Netherlands, in the Shell case. Other litigation examples, you can find it in the USA, but also in Germany. So I don't think, that the companies in France are being threatened in a more serious way, let's say. And as I already alluded to, I think companies will need to remain competitive, and if they like it or not, so they will have to find ways to decarbonize their business in order to reduce their greenhouse gases, so that they can remain on the market, let's say. So in this sense, I don't think the French duty of vigilance law is very much changing the regulatory landscape for companies for now. I think it's more an opportunity for companies to do their transition in a proactive way, and also it enables them more generally to foresee what would be the new European obligations, especially under the Corporate Social Due Diligence Directive, which will impose similar obligations on companies as the French law.
Thank you very much once again, Paul Mougeolle, for your participation and interesting input on the questions raised. To our listeners, thank you for your time, and we hope to have you again next month.